Hi, and welcome to another edition of the Trustcast Show. And I'm really happy to have on with us Mollie Mallory. Welcome to the show, Mollie.
Thanks for having me, Zane.
So, Mollie captained two national mock trial teams at Baylor Law, a program nicknamed the Marine Corps of Law School, and walked straight into a bet the company trials, or bet the company trials most lawyers don't see for a decade. Now she's a partner at Tillotson Johnson and Patton, the Dallas boutique firm known for taking on cases midstream and winning, including the firm's recent high profile victory against the Texas Attorney General over the state fair gun ban. Okay, so I write my first question. Baylor's practice court program is called the Marine Corps of Law School. What was the moment during that training when you realized trial work was what you were built for?
Yeah, I think I knew beforehand, and then that program really cemented it for me. When you like actually, standing up in front of crowds when the entire goal of the crowd is to critique and judge you, I think that that's a unique thing to enjoy. And
Mm-hmm.
that's what the practice court program is at Baylor. It was standing up in front of our professors and peers, knowing that the sole objective at the end of the day was for them to provide you very harsh feedback. And I liked it and didn't shy away from it. And so I knew after that that my inkling that I was going to want to be a trial lawyer was correct.
So you captained both the AAGA mock trial and the Tournament of Champions. What did leading those teams teach you that the classroom didn't?
I think it was the hands-on practical experience of taking, a case file, though not a real case, and having to learn it yourself and master it in a way that your peers were going to listen to you. Your
Mm-hmm.
teammates were going to actually look to you of what should our themes be? What are our best arguments? Why should I take advice from somebody who is at the same level as me, really? We're all in the same class together. I don't necessarily have any like, more experience than they do at this time. And so it teaches you that that's the way that this really works in practice, right? And I think that that's much more valuable than a lot of what you can learn from a lecture.
So I'm going to ask your indulgence here for a second. I'm going to turn this off and then turn it back on because I forgot to turn on my echo cancellation, and my video editor will curse me out yet again if I do that one more time. So bear with me for a second. Hi, and welcome to another edition of the Trustcast Show, and we're really happy to have Mollie Mallory with us. Welcome to the show, Mollie.
Thanks for having me, Zane.
So, Mollie captained two national mock trial teams at Baylor Law, a program nicknamed the Marine Corps of Law School, and walked straight into bet the company trials most lawyers don't see for a decade. And now she's a partner at Tillotson Johnson and Patton, the Dallas boutique firm known for taking on cases midstream and winning, including the firm's recent high profile victory against the Texas Attorney General over the state fair gun ban. So let me jump into the second part of my questions here. Before Tillotson, so you're now at, and just in case we lose any of this, before Tillotson, you were doing medical malpractice and catastrophic injury work at Cooper Scully. What made you leave that behind and switch to commercial litigation?
Yeah, I loved Cooper and Scully, and I loved my practice there, but I wanted to be able to be on both sides of the V. I wanted to be able to take on plaintiffs' cases too and continue doing the defendant's work, and that really wasn't an option at Cooper and Scully. They're a total defense firm, so I wanted to continue my trial work, but I wanted to be able to, when individuals came to me and said, "I have a really good case," I wanted to be able to take that as well. And Tillotson Patton has just allowed me that flexibility to do that.
So your firm's tagline is thinking inside the box or in the jury box. Walk me through what makes TJP different from a big firm's litigation department.
Yeah, I think what makes us the people to go to when you have a really complicated case that you think is actually going to go to trial and you need it to go to trial so that you can either, prove that you didn't do what plaintiff is saying or because you need to win your own case because you need to get something back or need to, prove that what you did was the right thing or what somebody else did was the wrong thing is we know how to really break down extremely complicated, complex issues for the jury. And everything we do in litigation is geared towards being able to speak to someone who, say, doesn't understand the way that a transaction worked or doesn't understand that contract, and to really get it down to the basics where after we do our opening statement, those jurors know exactly what we're talking about. It's simple for them and they can see the real story of our client and what our client is trying to get across. Rather than, I think firms and litigators in general have a tendency to get caught up in the weeds. And they really don't realize that a lot of these facts are too complicated for jurors to digest in the very short amount of time that we're allowed to stand up and speak to them.
So really, you're talking more about storytelling than you are about law and simplification of the story so that they understand it. Am I understanding what you're talking about?
That's exactly right. A lot of it is storytelling.
So what kind of training do you get in law school that allows you to go and be able to do that, or did you pick that up on the way since you've left?
I think it's both. At Baylor Law, they really, really focused on making sure it was drilled into us that we're speaking to jurors. That these jurors, they're smart, they're right a lot of the time, and if we can break it down and tell them a story, and that story resonates with them, then they're gonna be on your side. They're gonna get what you're trying to say. But then Jeff Tillotson, the founder of our firm, he's one of the best storytellers I've ever seen. There's really nothing like watching Jeff get in front of a jury and explain extremely complicated facts and turn it into a story that makes you want to be with him. And I think it's not only that practical experience from Baylor Law, but getting to watch Jeff in action all the time. And same with John Patton and Austin Irabali at our firm, just really tell those stories and absorbing that and, then replicating it yourself.
So TJP is known for getting hired midstream and sometimes a week before trial. What does the first 48 hours look like if a case is kind of dropped in your lap and so like help, our other lawyer was a boob and now we need somebody who knows what they're doing. How do you handle that kind of short timelines and deliver, like you say, a story? Sometimes that takes a while to absorb what
Yeah.
it is. What is the story?
Yeah, it's funny. We were just talking about this because this happened to us yesterday. We got a new case that we're taking on. It's a massive case, and we have hearings in it next week, and we just got on trial set in June, so not quite a week out from trial, but in the litigation world, it's pretty quick, and a lot has already been done. In the first 48 hours is just trying to figure out the cards that you've been dealt. Usually, when you're taking on a case like this, discovery is done, depositions have been done, experts have been designated, and so you have to look at what you have. I can't do anything about what was said in this deposition already.
Right.
Maybe they had different themes in mind, and now we're going a whole different route. So what can I use? What do I need to be worried about having in the future? And just it's really about taking all of that in and then just totally drilling down on what do we want to do from here. Instead of focusing on all the problems in the case, we need to find immediate solutions. How do we make this story better? What else do we need to do to make sure that we're setting ourselves up for immediate success on what we already have?
So the firm uses alternative fee arrangements, contingency, fixed, hybrid, instead of traditional hourly billing. How does that, or why does that matter for the client? How do you do that in a way that makes
Yeah.
sense for the firm and the client?
Yeah, I think that it's one of the things that is a hallmark of our firm and why we get to take so many different types of cases that say, a bigger commercial litigation firm or practice wouldn't be able to take. The reason we do it is because so much of the time you have someone who has been wronged and they don't necessarily have, an endless budget to pay hourly fees on a case. And so maybe they come in and say, we want to partner with you on, we want you to become just as invested in our success on this case as we are. And oftentimes that makes sense for us. We're super passionate about this. We want to win. And so if we think that they're right and they have good facts, then let's partner on it. We'll do it on a contingency fee agreement. Sometimes you can, like you just read, you can do mixed where you do flat fees and some contingency, but we're really with our size able to look at the case and look at the person or the client who's wanting to hire us and be flexible about that because we don't have all the different levels of approval to go through that some of the bigger firms have. The way that works internally in the firm and how we can still be successful doing that is making sure you have a good mix of everything you're doing. We really have a total mix of contingency and hourly, et cetera. And so it's really about staffing attorneys correctly and making sure everybody's spending their time in a way that it makes sense. Like all of our existences here are justified, right?
So Jeff Tillotson called out your big trial win alongside John Patton. What was the case and what was your role in it?
Yeah, so this was actually my first trial at the firm, and it was with John Patton. I second chaired it. He first chaired it, and it was a very interesting case. We represented a woman. She had a promissory note from a billionaire who's now deceased here in Dallas, said, I owe you X amount of money. We thought this is simple, we'll take this case and they'll want to settle early. They didn't. They wanted to go to trial. So we ended up going to trial. There was a lot of complicating external factors on that case that, they wanted to show the jury why our client didn't deserve the money, regardless of the piece of paper we had saying that she was owed it. And we tried the case. The jury was out for, I think it was 12 minutes. And they came back and gave us a verdict in our favor. And they actually told us that the only reason it took them that long is because they wanted to eat the lunch that they got for free that day. So we think that the jury thought it was a no-brainer. John was like incredibly talented in that case, but we were working right alongside each other. John and I have really partnered on a lot of cases together and handle multiple different clients together. And we have a very strong trial relationship and personal relationship, but he's very talented, and that win was really him.
So you went from partner to, or from associate to partner, not the other way around, at a pretty elite boutique firm in a couple of years. What do you think accelerated that trajectory?
Yeah, it's first of all, it's exciting that the firm allows those opportunities for young people because I think there's a lot of arbitrary holdbacks based on class year at certain firms. And I appreciate Jeff Tillotson and John Patton both recognizing that that would be a good move. But I really think it's about gaining, first of all, the trust of your peers, and then second, the trust of clients, making sure that you're available when those hard questions are being asked. Litigation is so stressful for clients. They often want to call just to talk. They don't understand what's going on. A lot of our clients aren't repeat litigators, so they don't understand how this works. And it's about, being one of those people that they can trust to walk them through this process, and also who is going to care so much about the result that they can tell and they can feel that you're working hard. You're not doing a shallow dive on their case, but you're doing a deep dive on their case, and that the hearings that lead up to trial and the document discovery, et cetera, is just as important to you as it is to them. I think that they saw, that client trust I gained and the trust of my peers, and thought that it made sense from just a career development standpoint, and the clients that I had started building on my own, that it made sense to promote me to partner.
Mhm. Well, congratulations. That's impressive.
Thank
So
you.
you first chair depositions and examine witnesses at trial. Take us inside preparation for a witness you know the other side is going to absolutely hammer.
Yeah. The first thing that I always do before I even, prep witnesses on how the questions I'm going to ask them, if it's my witness, is prep them on cross-examination. I actually spend probably 10 times as much time prepping my witnesses for cross-examination than I do their direct examination, because that's what gives your witness anxiety. So if you do practice cross-examinations with them and really try to, even if it's not what they actually end up getting asked, but just to put them in that situation where somebody's asking you leading questions and the tough stuff that you don't want to talk about, those reps and actually doing it in practice makes it so much easier when the day comes. And then on direct examination, when I'm actually getting to ask my own witness questions, it's about really letting them talk and preparing my questions in a way that I'm still getting the information from them, but I'm doing it in such a way that makes them the star, not me. I want the
Mhm.
jury to be looking at them and trust them, and to hear their story and their explanations for things, and not have just, me testifying on behalf of the witness.
Right. So your LinkedIn says you prepare every case as if you're going to trial, not settlement. So does that mindset change the way that you run discovery?
Yeah, I think absolutely. I think we even have a case right now. Often there's kind of two critical paths: settlement, which sometimes is really the best result for a case, and then there's trial and actually getting your case in front of a jury. And I always say those two paths can run at the same time, but your trial attorney, your lead, really needs to be focused on trial, because at the end of the day, that driving towards trial and pushing on document discovery and setting hearings that put your opponent in a position where they feel leverage is what drives settlement. So that, the more that you're just working and running towards trial, the more that the other side feels like, okay, they're actually going to do this. We're going to go do this. A lot of people don't want to try cases. We do. We like it. And so, and we're good at it. So we're not afraid. And if you prepare your case like you're not afraid, a lot of times that's what really pushes settlement.
So, what's the hardest part of translating a complex case, commercial dispute, into something that 12 jurors can easily understand?
The hardest part about it is making it simple for yourself first. I always joke we're kind of experts in everything. You almost nothing repeats itself in this world. We have clients, who they're a bank is at issue and then a crane is at issue, and it's like those are two separate universes. But you yourself have to become an expert in it first to be able to simplify it for a jury. I would say it's not a lot different from being a teacher. You need to, do your time to prepare to understand the subject so that you can teach it to somebody else. Because if you don't understand it, you're definitely not going to be able to simplify it for somebody else.
Okay, so I got rapid fire questions now. This is more fun kind of question. So, um, Baylor football, best game day tradition.
Oh, well, we're okay. So sailgating, we're on the river in Waco. And so people actually tailgate on boats. And that is by far my favorite part of the games. You like being on the boat day of. We're not very good at football always. So the pre-game is often the best part of the actual experience.
That sounds fun. Favorite thing to throw on the BBQ, barbecue.
Oh, I can smoke a really good brisket. I guess that's more on my smoker, but I would say probably a brisket or like a really good smash burger.
Okay. Last thing you painted.
Oh, I paint quite a bit. The last
I
thing I
know that's why
painted,
I ask it.
yeah, I was like, hey, thank you, like good one. The last thing I painted was the like a shadow of a cowboy for my living room. When I don't feel like buying something, I just paint it myself, and that's what I wanted in my living room. So I painted myself a cowboy.
Very fun. So, one trial lawyer, living or dead, you'd want to watch in a courtroom.
Oh, that's a really good one. Charlotte Aldis is a very, very successful, talented attorney in Dallas that I've heard a lot of stories about, who I would love to see in action. Um, I mean, and I love watching Jeff Tillotson. Really, there's nothing like it. It's like a privilege to get to watch him as often as I do. And then my grandpa is actually an attorney in Tyler, Texas. I've never gotten to see him in trial. He's 90 now. He just retired last year, and I would love to get to see him try a case.
We had relatives in Tyler, Texas.
Oh, fun.
Yeah. So, courtroom habit you're most superstitious about.
Oh, I was actually talking about this morning. I don't know that this counts as a courtroom habit, but I never ever schedule anything during a trial setting. I think that is like really, really bad juju. Even if you think the case is going to get continued, you count on a trial date happening. Another one is when I'm trying a case with Jeff, we have to have a box of Altoids out on the table, and it's like at the center of the table. And if it's not there, it's bad luck to me. Like we have to have our Altoid box on the table.
So, best advice you ever got from Jeff Tillotson.
Best advice I got from Jeff. He gave me some really good advice yesterday that I think every young lawyer should hear. And that is, just because you continue progressing and think you understand something doesn't mean you should stop asking questions. Doesn't mean you should stop asking questions for people underneath you, above you, across from you. Never feel like you know something so well that you don't need to gut check it or ask for help. Had something yesterday. I went to him and asked him. He said, just because you're a partner now doesn't mean that you don't need to, come sit down and talk through sit things through with me. That's the whole point of having, partners and peers in a firm and even friends in the legal field, is to be able to call them up and say, I have a really hard issue. Can you help me through this? I think that as lawyers get more experienced, they stop asking each other for help and asking for questions. And that's when your practice gets stale. And that's when, you really need to continue like asking, I want to learn about this. And what would you do in this situation?
So most firms settle. Your firm tries cases. So how do you convince a nervous client that going to trial is the right thing versus the less risky move of settling?
Yeah, that's a really tough one. I think it depends on the case and it depends on the client. A lot of times clients will say, even the most confident will say, I want to try this. I'm not nervous at all. And then you get to the week of trial and all of a sudden it's like, I thought we were going to settle this. It's about staying calm yourself and making sure that your confidence in the way that you've prepared, which we prepare well, is evident to the client. I love feeding clients information about what we're doing, because if they can see, look at everything we've done. We developed this week, even though we didn't have a hearing. This is what we've been working on, and this is what we've decided we're going to do on this. Let's have an update call where I can tell you about, what we're going to do with this witness, what we're going to do with you. And I think keeping them really informed, like they're in the loop too, they're part of the team. Usually it helps with that kind of confidence and calmness that clients really need to be able to actually go to trial. Sometimes though, we're telling people, you have an offer, you should take it a week before. Don't get me wrong. So, but a lot of times it's just calming confidence yourself.
So you handle both plaintiff and defense work. How do you do that and keep the right mentality? How does that or does switching sides make you sharper?
Can you say that again?
You handle, as I understand, you handle both plaintiff and defense work.
Yeah. Yeah.
So as far as switching sides, and the mentality that you have there, is kind of a big shift, or can be a big shift.
Yeah.
And I don't know if that's a big adjustment, or does that help make you sharper? Just a little insight there.
I think it helps make you sharper. It can be a big adjustment. If you're representing, a large company and they're the defendant and they're really just, they have no claims themselves, they're wanting, to slow down the pace, or maybe, they don't necessarily have their own like story to tell always. I mean, everybody always has a story to tell. It's a lot different from being on the side of somebody who feels wronged, who has, brought a lawsuit because they feel like they need to be made whole. And it's two attitudes, I think, sometimes. But I think being on the plaintiff side and seeing, okay, this is how I operate when I'm trying to drive a case forward, and really pushing towards my plaintiff's day in court is helpful when you're on the defense side and can think, okay, this is the mentality of my opposing counsel or of the party on the other side, and vice versa. I think it's extremely helpful on the defense side. I was telling a guy who was getting deposed the other day, and he was complaining about plaintiffs' attorneys and people who bring lawsuits. And I was like, I bring lawsuits too, and I represent people who feel they've been wronged and want to be made whole. And I think it's helpful as a defendant to put yourselves in their shoes. It makes you come off more trustworthy to a jury. It makes you more credible, because then you can actually see like why somebody might feel like you've done something to them that they, want to seek retribution for.
So this one is kind of an unusual one. So commercial litigation is dominated by older men. I mean, it just is. And when you walk into a courtroom, you're obviously not an older man.
Yes.
Do you do you feel that that sometimes people underestimate you, and can you use that to your advantage, or do you use that to your advantage?
Yeah, it's funny. There's a lot of the time I'm the only woman in the courtroom, other than in Dallas here, often the judge. Or sometimes I'm the only one woman in the courtroom, period. I think that it is 100% an advantage, because I'm underestimated, not only because, I'm a woman, but because I'm young, and people think, oh, they didn't send Jeff, they didn't send John, we've got this, little girl here today. And I think that people tend to, maybe become less prepared. I definitely am never unprepared. And so I try to use it to my advantage all I can. I think I'm hoping that we start to see more women, in commercial litigation. It feels like we talk about this at the firm all the time that there are more people, even junior to me, like women who we just see around. But it's a hard career. It's extremely time consuming and it's relatively inflexible. So it's difficult, but I'm hoping we start seeing, more women in the courtroom and sticking with it.
What does a typical week at your firm look like for you?
It's all over the place. We are just, so busy with so many interesting cases, but a typical week, say that we're not going to trial and we're not preparing for trial, is going to be, a deposition one day, preparing for that deposition over the weekend or on Monday, hearings that you're prepping for all week, and then just making sure the wheels are turning on every matter that you're handling. So communicating with associates, communicating with Jeff and John and Austin to make sure that, my matter is not interfering with something that they have going on. Where does everybody need to be? And then keeping the clients appraised of what's going on, just constantly updating them and making sure that they feel good about where their case is.
So, tell me about one recent case that you were involved in that our audience might find, very interesting.
Yeah, we had in February, this has been such a fun quarter, but in February, we got hired on a Tuesday. We got hired by four individuals who had left a recruiting company to start their own company. And they came to us and said, we have a temporary injunction hearing on Thursday. A temporary injunction hearing is basically a mini trial.
Mm-hmm.
And they said, can you handle this for us? We have no attorney. They're trying to basically halt our business completely, which would shut down all of their streams of income. This is what they do this is their livelihood. These people, they're saying they were, you know, they had non-compete agreements, had stolen trade secrets, etc. All these accusations against these people they had never litigated before. So literally, we take the case on Tuesday, spend all day Wednesday, far into Wednesday night preparing, and then Thursday went to court in Fort Worth. We had a full temporary injunction hearing for these four individuals who I've had very few clients as this scared and just really worried that they weren't going to be able to, get a paycheck the following week to put food on the table for their family, to support their kids, to pay their mortgages. They were really nervous. And it was against a big firm here in Dallas. They represented the company who was, bringing all the claims, who was mad these four had left the company. And we had a full-on hearing. Pierce Ilmer, one of the associates from our firm, assisted me. We had seven witnesses, did openings, closings, and at the end of it, the judge just said the temporary injunction is denied. And my clients were like over the moon thrilled. That meant that they were fine. They could continue their business. Nothing was going to happen. And then the following few weeks later, the plaintiffs, the company actually dropped all their claims, just didn't pursue it at all. So it was like huge win that makes you feel really good about what you do, because those four people really needed somebody to stand up for them and say they didn't do anything wrong. You can't just threaten them with litigation, and try to scare them into giving you something that, you don't deserve.
Right. So that would be scary. Actually, I have twice had non-compete things thrown in my
Yeah.
face.
Yeah. It's
And they're
crazy what
very
companies will
frustrating.
do. Hmm.
So, what would you tell a law student right now who's wants to be a trial lawyer but keeps hearing no one goes to trial anymore?
I would say that's not true. Find the right place to go. If you really want to try cases, if you really want to be a trial lawyer, find the right people to do it with and to learn from. And then go out there and get out there and find the right cases that are right to go to trial. And just practice and get good at it, and trial will find you. People told me that all the time. They said nobody tries cases anymore, and that we have what, 40 trials set this year. I'm over exaggerating, but it's just, it happens all the time.
Mhm.
We try cases every year. There's people down at the courthouse right now trying cases. Don't listen to them. Get good at it and go find people who are good at it too, and you'll try cases.
So, there are a lot of lawyers though that don't that really just settle. I mean, that's their whole the whole practice is and so so this is, I'm asking for conjecture. If you go to a firm and you think that they're trial lawyers, but in fact you get into it and they're wanting to settle, and I can think of several, I can think of multiple, that isn't it, you're really weakening your position. Or do you have any? I guess I just want a little comment or thought about that.
Yeah, I always say there's a difference between a litigator and a trial lawyer. There's a lot of people who litigate, and then there's very few trial lawyers. Litigating is what you just said, filing a lawsuit or answering a lawsuit, and then never having any intentions of trying it. Telling your client the whole time, we're going to do mediation as soon as possible. I'm working on settlement the whole time, and that's your focus. Continuing the trial until somebody, everybody's happy with the number on the table or the resolution. But what I would tell people who actually want to try cases and it's confusing. When you come out of law school, you're like, so and so has a big commercial litigation group that they try cases, whatever it may be. Do your research. Go look. You can look at the Dallas County dockets. You can look at there's like a verdict sheet that comes out every week of what the jury verdicts were. Go look at the firms who are actually at the courthouse trying cases. Same with the federal courthouse. Who's down there? Who's actually arguing hearings? Who's actually at the courthouse? A lot of these firms and groups are not at the courthouse, and you can figure it out. So if you really want to be around trial lawyers, go find one and ask them, where should I go? We all know. All of the trial lawyers know who's trying cases, and we also know who's not at the courthouse. So I think it's really just about kind of figuring out how you can distinguish between the two, so that you can put yourself in a position where you're actually around people who want to and are trained to try cases.
Well, okay. Well, so where can people find you, learn more about your firm, or if they want to contact you directly, what's the best way to get in touch?
Yeah, our website is tillotsonlaw.com. My little page, my bio page on the website, I think has my email address, but if not, people are welcome to contact me directly. It's just mmallory@tillotsonlaw.com. And I'm always happy to answer any questions, especially for young people who are, wanting to be trial lawyers.
Molly, thanks so much for coming on. I really enjoyed it. This is a little bit different than most of the podcasts I do, but I really, it's a refreshing change of pace. So thanks.
Fun. I'm glad. It was really fun. Thanks for having me, Zane.